And will your client waive the formal reading of the indictment?
She will.
Let's see, give me just a second. Ms. Reinhart, you're charged with the second-degree felony offense of assault on a peace officer from December 22nd of 2024. And how do you plead to that charge? Oh, I'm sorry. Yeah, I see now. Hold on. Y'all are going on a lesser included, Class A.
Position arrest.
Okay. All right, so in 25-0089, the state has elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest from December 22nd of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Shalander?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Reinhart is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, then this is a great opportunity because you don't have a conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have this conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court and you could be found guilty of the offense and sentenced to the Jefferson County Correctional Facility for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom, and the probation, she's at that desk right there. She's going to call you up in a few minutes to go over your paperwork. And you're going to help get that attachment?
Sarah's going to email it to you.
Okay, thank you. All right, thank you.
Well, I could do it.
That's between y'all. It's your job, but if he's going to do it, then it just has to be done today because once the case is closed out, you can't get to the portal. So
Okay.
that's why we need it, just so y'all make sure.
All right, thank you.
Good morning.
Good morning. You're Rodney Latiolas,
Yes, ma'am.
and Mr. Latiolas was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
None from the defense, Your Honor.
Are you sure?
Well, he does take responsibility for it. We did review his BAC level at the time of the stop, and
So here's the thing, Mr. Latiolas, your BAC was .229. .229. What you said in here is that I'd had a drink the night before, but not that day, and that you hadn't eaten anything. So you're saying you had a drink the day before, and you were a .229 when you got this. That doesn't make any
No, ma'am.
sense.
I went and stayed at a friend of mine's house, and we stayed up, barbecued, and drank till probably 4 in the morning,
Okay,
and then went to bed.
okay, all right. Anything, Ms. Malfino, then?
No, Judge, only if the court thinks that the length of probation is appropriate, I understand if you feel the need to change that.
and we are. I did speak with Mr. Nichols about the 10 days. If Mr. Latiolas could serve him on the weekends.
Are you working, Mr. Latiolas?
No, ma'am.
All right.
He has a disease that he sees doctors weekly for, and so that was the reason.
And I know Mr. Nichols did discuss his medical condition with Ms.
And,
last week.
and the therapy,
Right, your physical therapy.
yes.
All right, so what day are your doctor's appointments and therapy on the same days each week?
No, ma'am, my therapy's daily. I have a device that's prescribed that I use 2 hours in the morning and 2 hours in the evening.
Okay, so I mean, that's something that you're gonna have to have it taken care of in jail anyway, even if it's weekends, right?
I don't know if they'll let me bring the device in.
What is your schedule? What is your weekly schedule with the doctor and the
Well,
therapy?
I'm seeing 3 different doctors. The therapy's daily, and I see one doctor once a week, one doctor bi-weekly, and then one monthly.
Give me a second. Okay. So what I'll do, you're just gonna have to get it figured out, with the jail if they do or don't allow, that device in. If not, you'll have to work it out, where you're just without it for a couple of days. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you, find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. I'm going to suspend that, place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That will include 10 days mandatory upfront time. I will allow you to serve that on weekends. You will be required and ordered to report to the Jefferson County Jail to start that this Friday, June 27th at 6 o'clock p.m. And so you have to be there at 6 o'clock. You need to be on time. If you're late, it's a violation of your probation. If you show up under the influence, a lot of people think they're going to show up under the influence and sleep it off over the weekend. That's a violation of your probation. You'll be right back in here. And you'll do those weekends from Friday to Sunday until the 10 days are satisfied. Also, I am going to order that you enter and successfully complete the Jefferson County Drug Intervention Program. That's the JCDI program. It's an outpatient treatment program to make sure that you have all the tools necessary to stop drinking and stay on probation and not end up in prison. If you don't make it successfully through that program, you're going to end up right back in here looking at the 10 years. Do you understand?
Yes, Your Honor.
You're also ordered to have the auto ignition interlock device. Do you already have that on your vehicle?
No, ma'am.
Doesn't drive.
I'm not driving.
Okay.
My truck's not even legal. I don't have insurance on it.
So as long as you're not driving, obviously you don't have to have that, but you're not allowed to drive any vehicle. So you can't borrow a vehicle or rent a vehicle, nothing like that unless it has that device on it, okay?
Yes, ma'am.
So again, if you do everything you're supposed to while you're on probation, this is a good opportunity because for all practical purposes, your case here in court is over and you'll serve that 10-year term while you're out on probation. The other side to that, again, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 10-year sentence that you agreed to. Do you understand?
I do understand.
And I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. Good luck to you, sir. Good morning, sir. You are Rosendo Ochoa?
Yes, ma'am.
And Mr. Ochoa, in cause number 240367, you were previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Are there any additions or corrections?
None from the defense.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $300 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity. You're only 21, right? And it looks like this is your only criminal hit. You've never been in trouble before. And so at the end of this probation, if you have been successful, the case will actually be dismissed and you will never be a convicted felon, which is a very big deal.
I don't have to worry about it getting expunged on the record.
Well, you're not going to be able to get an expungement, but if you're successful, there are some other ways to get it not necessarily completely expunged, but at least kind of hidden on your record. It's called a non-disclosure, and you can talk to an attorney at the end of that probation period about that. Also, it's important that you know, I sign early terminations from probation all the time. So if you get out there and you do everything you're supposed to up front, get your community service done, get those fees paid, don't violate, don't test positive for anything, then you actually can get off your probation much earlier than that 5 years, okay? But you got to do everything right, and you got to do it right up front. If you violate any condition of probation, you can be brought back into court, found guilty of the offense, so you become a convicted felon, and you could be sentenced anywhere in the range of punishment in your case, which is up to 10 years in prison. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you when she's ready to go over your paperwork. All right, good luck to you, sir. Good morning, you're Ashley Sanders, and this is 241650. Ms. Sanders is charged with theft of service, and Mr. Kelly, what is the announcement?
Judge, if I may, the court has been very gracious and lenient with us in resetting this and trying to obtain a forensic audit. We reached out again this morning, let them know they have a date certain that we must have it by in case we would likely be dismissed. They were made aware of that before court this morning. If I may just have that one final, say last reset, I won't ask for it.
Okay, all right, any issues?
No.
I'm sure you're from that. Okay, we'll do one last final reset. Stay in touch with Mr. Kelly. He'll let you know when you need to be
And
back.
of course, if I do in fact get that, Judge, I will turn it over immediately.
Perfect. Thank you. Y'all are free to go. Good morning. You're Shy Brooks. And this is 242034. Mr. Brooks is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, I've talked to Mr. Brooks. Evidently, he had my incorrect contact information. We've taken care of that this morning because there is some media that I received in relation to this case I need to go over with him.
Okay. So, Mr. Brooks, I'm going to reset your case one more time. It's important that you make sure and call soon so that you can get an appointment to go see Mr. Lewis and go through all that information, okay? All right. We'll see you at the next court day. You're free to go.
All right, thank you.
Good morning, sir. Are you Guillermo Galvin? And this is 242321. Mr. Galvin's charged with driving while intoxicated, third or more. And what is the announcement?
Judge, this will be a plea. We just need to get him a scram device to show the prosecution that he is correct in his statement that he is no longer drinking. And so if we could have a 60-day reset, just because we need to...
30 days. This has been since January, and we're getting close now to end of June. So we're going to do a 30-day reset, get that on as quickly as you possibly can so that she can get some of those results. Let's just see where we are at the next court date. All right? Thank you. All right, you're free to go, sir. Good morning, ma'am. Are you Alexandria Bledsoe? And Ms. Bledsoe in 250004 is charged with abandoning or endangering a child with intent to return. And what is the announcement?
Judge, we received an offer this morning. Mr. Smith was kind enough to relay the offer from Mr. Hoffpower. Ms. Bledsoe just would like to meet with me and discuss the options on the plea. We just asked for one single reset.
All right, well, any issues that you see, Mr. Smith? All right, we'll do a normal reset. Ms. Bledsoe, make sure you get with Mr. Rennick so y'all can visit about what your options are, and we'll get an announcement at the next court date.
Today's courtroom wasn't just about punishment. It was about second chances, broken promises, and the difficult choices judges have to make every single day. Some defendants walked in asking for mercy, but their own history spoke louder than their words. Others were given one more opportunity, with a clear warning that the next mistake could cost them everything. One thing became painfully clear throughout these hearings. The justice system doesn't judge people by what they promise. It's forced to judge them by what they've already done. Every decision carried consequences. Every sentence reflected years of choices, not just one bad day. But here's the question that stays with us after the courtroom empties. How many chances should someone get before accountability has to come first? Let me know what you think in the comments. Were these judges fair, too harsh, or exactly right? And if you enjoy real courtroom breakdowns, legal analysis, and uncensored justice content, don't forget to subscribe, because the next case might be even more shocking than this one.